Good morning, Ms. Dews.
Here's a quick legal reality check. The stolen items may only total $120, but the charge itself is still a big deal. The judge wasted no time laying down strict rules, like banning her from every Walmart. It sounds dramatic, but that order is very real and enforceable. What's your take? Fair call or over the top?
Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On March 18th, 2025, at 5:21 p.m., an officer was dispatched to a theft at Walmart with a female in custody. Upon arrival, the officer took custody of the female identified by her Texas driver's license. The officer searched the defendant before passing custody over to another officer. That officer spoke to the loss prevention officer, who stated he was following the defendant in the store and observed her concealing items in her purse and backpack. This was done in a blind spot of the cameras, so they were not videos. The defendant then continued shopping before checking out and paying for some items. The defendant did not pay for the items she had concealed in the bags and passed all points of sale before the loss prevention officer stopped her. The defendant admitted to stealing before turning the items back over. The total value of the items was $120.86.
Thank you. Ms. Dews, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walmart for any reason whatsoever. If I find that you do, I will revoke your bonds, put you in jail, and no more PR bonds for you. Do you understand?
Yes, sir.
Likewise, if I find that you pick up any new cases, your bond will be revoked. You will go into custody, ma'am. Do you have the ability to hire a lawyer? Okay, I will have you fill out an application. Deputy Miranda is going to give you an application. I'm going to have you sign a receipt with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions ready. Do not leave until you sign them. Okay? Please. Do you mind filing those? No going to any Walmart? Anywhere.
No Walmarts anywhere?
Anywhere.
Thank you,
Frank Reyes.
Yes, sir.
Mr. Reyes, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Officer was dispatched to a minor crash in Harris County, Texas, where the defendant had rear-ended the complaining witness. Upon contact, the officer found the defendant in the driver's seat, slipping in and out of consciousness. When the officer woke the defendant up, the defendant attempted to start his car and drive away, but at that point, officers had his keys. The officers did not notice any injuries on the defendant. When the defendant exited the car, he was unsteady, and officers observed an odor of alcoholic beverages, bloodshot eyes, and slurred speech. The defendant admitted to drinking at a bar earlier.
Wow.
That's a clean sweep on every sobriety test. 6 for 6 on the eyes, 8 for 8 on the walk and turn, and 4 for 4 on the one-leg stand. Basically, the DUI equivalent of a hat trick. And then the judge hits with a zero-tolerance warning, saying not even a burning building is an excuse to drive drunk. Tough stance or too harsh?
Standardized foot sobriety tests were conducted, and the officers observed 6 out of 6 on the HGN, 8 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. While en route to the Joint Processing Center, the defendant fell asleep in the officer's vehicle. At the Joint Processing Center, officer read the DIC and defendant consented. However, the defendant fell asleep again and began vomiting. The defendant was transported to the hospital, and a blood warrant was signed and executed.
So no breath test was done.
No, you don't.
Mr. Can you run his license, please? See if he has a valid license.
Yes, Your Honor.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not, I'm going to give you a portable device. You're not allowed to drive any vehicle from now on that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock on it, I'm going to put you in jail and I'm going to make your bond high. Do you understand?
I understand.
It says ineligible.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. Mr. Reyes, heed this warning. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand?
I understand.
You cannot justify driving for any reason. I don't care if there's a burning building and you have to save 50 babies. Do you understand? Mm-hmm. I'm sending notice now to DPS so that every single officer in the state knows that you are not allowed to drive a vehicle that doesn't have an interlock. If you're caught driving a vehicle, it doesn't have an interlock, they will arrest you and put you in jail. I am now giving you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You will also be tested for illegal drugs as well. You test positive, you consume alcohol, into jail you will go. Do you have the ability to hire lawyers, sir?
I do.
We're going to give you time. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria. We'll have you sign a reset. You will get with police you for your bond conditions, and after that, you're free to go.
Please confirm that you can.
Good morning, Mr. Sullivan. Sir, you were charged with assault with a family member. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On March 23rd, 2025, at approximately 15:39 hours, the law enforcement officer was dispatched to an address in Harris County, Texas. In reference to a disturbance. When the law enforcement officer arrived on scene, they made contact with a witness who stated that her husband, the defendant, had been arguing because her adult daughter does not like the defendant and asked the complaining witness to pick between having a relationship with her and her grandchildren or the defendant. The complaining witness stated she decided to sever a relationship with her daughter and informed the defendant that she would be moving back to Arizona. The complaining witness stated this upset the defendant and he began arguing with her. She then expressed that she hated him and this made the defendant more upset and he told her to hit him if she hated him so much. The complaining witness stated she hit Mr. Sullivan with a closed fist on the head and face area 3 times before losing balance, slipping and falling. This fall caused her to hit her face on their bedroom dresser. The complainant then said she got up and crawled into bed.
This one gets complicated. She admits throwing the first punch, but he answered with force that left visible injuries. In domestic violence law, starting it doesn't cancel out accountability for going too far. That's the gray area juries wrestle with. So who's the real victim here? Should both face charges, or just one?
And she was laying on the furthest corner of the bed, closest to the wall, and covered her body with a blanket. The complainant witness stated that approximately 10 minutes went by. Mr. Sullivan, the defendant, continued to argue with her. He crawled on bed, grabbed her, flipped her over, for her back was on the mattress, and used his body weight on top of her while placing both hands on her upper arms to hold her down. The complainant witness stated this caused her pain, and she was able to free one of her arms and use her hand to grab the defendant's genital area and making him let go of her completely. The defendant then used his right hand and punched the complaining witness on her mouth, causing pain and visible injury. The complaining witness added the fight then diminished, is that the law enforcement officer observed visible injuries, including large purple bruises on both arms and injuries to the top and bottom inner glove.
Lays, are you hearing this?
Yes, Your Honor.
Interesting. So she's the initial aggressor, though, correct?
Your Honor,
So it looks like he says, hey, hit me, antagonizing. She gets into it. She pops him, what, 3 times in the mouth, you say?
Yes, Your Honor.
Don't say anything. Sorry.
So Your Honor, only thing I would ask is, this is not home court's case. If we can just stand down, wait for the DVD prosecutor to be here. I don't know if he's spoken with the complainant yet, if he has anything more to add. I would just ask the court to withhold the finding until we can get the prosecutor.
All right, Mr. Sullivan, just do me a favor. Will you just take a seat behind the jury box? I'm going to get, I'm going to also appoint him a lawyer. If you don't mind, I'm going to appoint him someone as well so we can do just.
That's fully fine, Your Honor. Let me, and I'll email DVDs. Yeah.
Okay, all right.
Thank you.
Do me a favor, just take a seat for me real quick, all right?
All right, Judge, next is.
You're Abner Guzman.
Guzman.
Yes.
Mr. Guzman, you're charged with displaying a fictitious license plate. 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you. On March 24th, 2025, at around 11:20 a.m., officers were dispatched to a B&B call at 2520 Airline Drive in Harris County, Texas. Upon arrival, officers observed the defendant's vehicle parked in the west side parking lot near the fence of the Houston Farmers Market.
Houston Farmers Market.
with the front passenger window
con
broken.
la ventanilla del pasajero del frente quebrada.
Officers conducted a
Los
vehicle
oficiales
check
hicieron un registro de vehículo
on the temp license
en la
plate
licencia de manejar temporal.
and returned it
Pero
without
la
match
placa y regresó, lo tenía ahí,
the defendant's vehicle.
del acusado, el vehículo del acusado. Perdón.
At 12
A
p.m.,
las 12 p.m.
the defendant arrived
el
on
acusado
scene,
llegó.
told officers that he was the
Le
owner of
dijo
the
al oficial que
vehicle.
era el dueño del vehículo.
Defendant was
El
detained.
acusado fue detenido.
Defendant said he had purchased the
Él
vehicle
compró el vehículo
5 years prior
5 años anterior
in Florida
en la Florida.
and paid an additional fee for the seller
Costas adicionales al vendedor
to change the title
para que
to
le
the
cambiara el título,
but the seller did not do that.
pero el vendedor no lo hizo.
Defendant stated he met a
El
woman
acusado declaró que él conoció a una mujer
on WhatsApp
en WhatsApp
who offered him a
que
fake
le
temporary license
ofreció
plate
una placa falsa temporal
for $40,
por $40
which he purchased.
que él compró.
Defendant stated he had
El
been
acusado
driving the
dijo que había
vehicle
estado manejando el vehículo
with fake temporary
con
license
las
plate
placas temporales falsas
for 4 years.
por 4 años.
The defendant was
El
ID'd by his
acusado fue
Guatemalan passport.
identificado por el pasaporte de Guatemala.
Mr. Guzman, I'm going to find that there's
Guzmán,
sufficient
que hay
probable cause to go
suficiente
forward.
causa para seguir hacia adelante con su caso.
If you do not have a Texas
Si
driver
usted no tiene
license
licencia de
and
manejar de
liability
Texas,
insurance in your
el
name,
seguro,
you are not allowed
su
to
nombre
drive.
no se le
I
permite
don't
manejar.
care what you need
A
to
mí
do in
no
this
me
life.
importa qué tienes que
If
hacer.
you're not
con
properly
esto. Si
licensed
usted no tiene
and have
licencia
insurance,
y tiene seguro de carro,
not
no
drive.
maneje.
You'll be signing a promise with me. This is an affidavit that you're going to swear to me that you're not going to drive.
Usted no va a
You
manejar,
cannot justify driving for any reason.
manejar
If I find that you do, I will revoke your bond and put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail,
a la cárcel,
and immigration finds you,
encuentra
they
el
will put a detainer on you and you will be stuck like Chuck in there until this case is over with,
caso se
and then you
acabe.
get shipped off to immigration.
Usted
Do you understand?
entiende.
Sí, sí.
Yes,
Do not.
no maneje.
This is the only bond condition that you have. Do not pick up any new cases as well. If I find that you're a danger to my community, likewise, I will put you in jail.
Igualmente no.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him. If he tells me that he cannot get a hold of you because you're playing games, you're not responding to phone calls, text messages, likewise, I will revoke your bond. Do you understand?
Él lo entiende. Yes.
Okay. I'll have you sign a receipt of Victoria. We'll have you swear to us that you're not going to drive, and after that, you're free to go.
Thank you, Judge. Maybe excuse me. Thank you.
Yeah, take care. Hey,
Aaron Durden, bond violation report. You said bring him today. He's here.
come up, Mr. Durden. We're here on yet another bond violation report. It is now alleged that the client was instructed to install an ignition interlock device, not to tamper with the device, to blow into it. And from 2/20 to 3/20/25, you skipped 8 tests, not using the device as instructed.
I'll explain, Judge.
Please.
All those violations except one are on the same day. If you look at the photos, the person there's only one person in any of the photos. It's not him. He owns a company. He allowed his employees to drive the truck. They didn't understand the deal. All the other pictures show nobody in the truck. What they did, they're roofers. They just left the truck running while they were doing work to keep the climate control on. He has since clarified that. We've emailed pretrial last week asking them to try to get the photos before the violation so we could see who was actually driving the truck, but we didn't hear any response.
He has guys, does he have a blow schedule that he's supposed to blow? He has a blow schedule. He's supposed to blow at certain times and he's not blowing.
Are you not blowing at certain times?
That's not, no, that's not true, Your Honor.
I have here 8 skip tests.
No. So one of my guys was driving the truck and he did not, I didn't instruct him that when you stop the vehicle, that you can't just leave it running. So he wasn't informed about that. So he just left the truck.
But it was rolling retests that were skipped. That's the allegation, rolling retests. So somebody started the truck, got out of the truck and left it running. And it just kept saying blow, blow, blow. If you look at the times and date, they're like 5 minutes apart for 15 or 20 minutes.
Yes, Judge, I do see that it's the rolling retest. As far as what specifically that entails, honestly, that's something I haven't encountered before.
I haven't either, but bottom line, he's supposed to test at certain times.
Yes, but that would be a missing test, but the allegation is in the bond violation, rolling retest.
So yes, there's no allegation that he has missed his flow schedule.
What times, do you have this time set that he's supposed to actually blow?
I can reach out to the manager and get that information.
Do you mind? I'd like to know what specific times is he supposed to test?
Yes.
And did he actually do it on that times, or is it someone else blowing? That's what I'd like. So let me see what they say and then we'll come back.
Judge, I have Odiambo on today's docket. He's doing the DWI-PTI program. He just needs a little more time to get the device.
Last name is?
Marina Odiambo. It's hyphenated. She's been having some financial issues, and so he's trying to get some money together to get the alcohol monitoring device. And we also need to submit the industry affidavit, but he's provided that to me to get the
213 days old.
Just we can get 2 weeks just for him to get the device. That's all we need. We have the contract already, and we just need to get the fee waived as well.
Bring him up.
Yes, Judge. I'm just trying to get this wrapped up, Judge, and we're really close.
So are you doing that for the fee, right, James?
Yes, Judge, we have to submit the device, or we have to submit the industry affidavit for the $300 fee, and then he also has to get the alcohol monitoring device.
Filled out the affidavit.
Judge, he has that filled out. It's just I need to get a PDF copy of it, and he says he can scan that to me.
You have everything now because we can scan it, bring him back and I can.
No, Judge, he took photos of it, and that's not going to work for them.
Your case is 215 days old. I'm not giving you any more time after that. It's not, if you don't have it done, I'm going to immediately set you for trial or you're going to take a plea bargain agreement from the state. But I'm not giving you any more time after that. You need to have everything done by that time. You need to submit the affidavit today, not tomorrow, not next week, because they need time to review it to see if they're going to grant it for you. I will not give you any more time after this 2 weeks. If you don't have it done, I will bring you back day for day until you have it done. Do you understand? Okay.
Thank you, Judge. Can I get 2 weeks? Thank you, Judge.
I just got hired on Miss McKelvey. This is the one you emailed me about. She's in the box. Pretrial has indicated to me that she did take a test last Tuesday and she did test negative. She tried to go to Quest, which we sent her to. They wouldn't take it because they didn't have enough information. But she ended up testing, I guess, through pretrial.
Yes.
Okay.
When did you test last?
Tuesday.
Tuesday, just the 25th of March.
Okay, come up, Ms. McKelvey. I'll just admonish her now.
Thanks, Judge. I told her zero tolerance. I mean, she's a real sweet lady. I don't think you're going to have any issues with her in the future.
It's no tolerance. If you miss again, it's not going to go well. All I'm asking you to do is show up when they call you to take a test. You understand?
Yes, sir.
So right now, nothing's going to happen today. But if it happens again where you miss a test, then I will issue a warrant. No tolerance. You understand?
Yes,
You're
sir.
not to use any alcohol. You're not to use illegal drugs. And that's how we ensure that it doesn't happen. Understand?
Yes, sir.
Okay. All right, Carter.
May she sit in the audience? Thank you.
Good morning, Your Honor.
How are you?
I'm fine. I don't have any big problems today.
Something nice.
All I need is a reset for 45 days. The prosecution and I have come to an agreement. Christian Willis. The prosecution and I have come to an agreement as to the resolution of this case. He just needs about 30 days in order to.
It's nearly 200 days now. What do you, what did they offer? What did they offer?
We've offered a PTI now, Your Honor.
And what did,
What I forfeiture the weapon and gun safety class and a drug and alcohol awareness class, I believe. And it's drug awareness class, I believe.
so I'm gonna give him 2 weeks to get the stuff done.
2 weeks?
Yeah, it shouldn't take that long. It's a gun safety class, it's probably 2 hours.
Yes.
And the other class also is just a couple hours.
So we need 3 weeks instead of 2? Because I still have balance.
3 weeks.
3 weeks. Thank you,
Mr.
sir.
Willis, Where's Mr. Willis? Come up.
This is the first time ever getting in any.
Mr. Willis, he has secured you an amazing deal where if you do 2 simple classes, both of your cases will get dismissed. If you do not have if you don't have them done in 3 weeks, I'm not going to take anything else. I will immediately set your case for trial. Do you understand? There's no excuse why you can't get both classes done in 3 weeks. All right, Mr. Cashin.
Thank you, sir.
See you.
See you next time.
Take care. Hey.
Judge, we're here on Mr. Aziz. We're newly retained on the case, Judge. Newly retained on the case.
Oh, you retained?
Yes.
Got it. Okay, so come on up. We were waiting because he said that he hired a lawyer. We were waiting to see the voice. Come on up, Judge. So have we done PC on this case yet?
Judge, he was THA. They just had to sign on.
Okay, so we have here, do you mind doing me a favor? Can you run his license to see if he has a license? Sure. This is a failure to stop and give him information.
Yes, sir.
Leaving the scene of an accident. So I just want to make sure that if you're going to drive, that you have a valid Texas driver license and liability insurance. If you do, then you may continue to drive. If you don't, then I'm making it a bond condition that you not drive until you have both of those things.
Yes, Judge.
Yeah, disagree with defendant is eligible.
Okay, you do not have a Texas driver license.
I have a California driver's license. I was stationed in California. I'm a veteran.
Is it eligible?
It does say eligible, Your Honor.
Okay. All right, so one of your other bond conditions is you are not allowed to drive unless you have liability insurance in your name. That is a bond condition. If I find that you drive without car insurance, because all I'm asking you to do is follow the law. If I find that you don't, then I'm going to put you in jail. You understand? Great. You've got a lawyer. Because you have a lawyer, we will waive your appearance. So you don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you if and when you have to come back to court.
Quick question.
No.
Do I just need to come back with like my insurance and give it to them so that they know that it's valid?
Yeah, just let them know, then they can show it to us so that we can verify it and then you're good to go. But like I said, I'm waiving your appearance. You don't have to waste your time coming to court, but just stay in touch with them and they'll tell you. If they tell me they can't get a hold of you because you're gone, then I will issue a warrant of arrest.
Okay, that's right.
Don't pick up any new cases. Got it?
That's right.
We're good.
Thank you.
Thanks, Judge.
So don't leave until you sign the conditions and then after that you're free to go.
Yes.
So he filed no driving without a valid license and liability insurance.
Yes, Your Honor.
Okay,
Thank you, Your Honor.
that's, have fun.
Urging on Jasmine Tovar Martinez, Judge. Apparently she had a BVR. On Friday, she came to court. She was sent to go get drug tested and it's negative. She is present. Martinez had a cause of mercy like that. That's it. That's the one. Judge, it's 254 8319.
I think it just.
Ms. Tovar, come up. Did we put a scram on her?
I believe that's what happened. I wasn't here on Friday. We should do this.
Do you mind checking?
Yes, Graham device that Friday.
That's positive again. It's not going to go well for you. You better know every single thing that you put in your body before you do. If I see that you have a positive and you try to tell me it's mouthwash, it's a tequila lollipop, it's hair dye, I don't care. No more excuses. You understand? Okay? All right.
Thank you, Judge.
Yes, sir.
Yes.
Okay, have a seat. Give me 1 second.
Who's the guy that took in? Mark to you.
Oh, James.
What was all the letters? No, I don't need it. Yeah.
So 30,006.
30,000?
And 6. No, maybe I'll make it higher.
What do you think? No, they say it's ball. I let them know. Okay.
Did you hear that? Yes. Safety.